Mr. Hartung, can I ask which case you're hearing?
Joseph Brown.
Hi, this is Judge Anzalone. I am calling because I am ready for Joseph Brown and for Antoine Carter and Demario Cooper.
Okay, man.
All right, thank you.
You're welcome.
All right, I have somebody just admitted to the Zoom room. Screen name says CME. Could you start your audio for me, please? Hi, can I ask your name?
Chad Ely.
Say it again.
Chad Ely.
All right. All right, Mr. Ely, your attorney is Charles Noe, and he is not here yet. So I'm gonna change your screen name and I'm gonna put his initials after your name, all right?
Yes, ma'am.
Your Honor, if I may, I actually just gave the noli to Brenda on that case. I think Mr. Noe had asked the court if he and his client could be excused given that fact.
So, Mr. Ely, it appears your case has been dismissed, so you're all set.
Okay, thank you.
You're welcome. Have a good day.
You too.
Thank you.
It's been dismissed. You're all set. Yep.
Can you guys see the screen? Because you can move up if you want to. All right. Mr. Malaro, I do have Charity Smith in the waiting room, so I can bring her in. This is Miss Smith. Can you hear me? And she's frozen.
Yes, can you hear me?
Yep, I can. All right. This is in the matter of the people of the state of Michigan versus Charity Christina Smith, file number 24-22056FH. I have Salvatore Malaro appearing on behalf of Miss Smith, and who is my prosecutor on this file? Alexander Bayonetto. This is a date and time set for a pretrial conference. Mr. Malaro, how would you like to proceed with Ms. Smith?
Judge, what I'd like to do is adjourn this one more time. Ms. Smith just resolved the matter down in district court or sentencings next week, it looks like. And then I think we'll be ready to resolve this at that time.
All right, so I'm going to set this over to April 30th at 8:30 in the morning. Mr. Malaro, obviously, if a resolution is reached before that, just call and we'll get you in on any other day than a Wednesday, all right?
Yes, Ms. Smith, does that interfere with your schooling at Jackson?
She's muted. Ms. Smith, unmute your device, please.
It's at 8:30.
Yes, ma'am.
Yes.
No, that's perfect.
Okay. Yeah, we're good, Judge. Thank you.
All right, Ms. Smith, we'll see you back on April 30th at 8:30 in the morning. And Mr. Malaro, you'll prepare the stipend order to adjourn?
Yes, I will, Your Honor.
All right, thank you.
Yep.
All right, you're all set, Ms. Smith. So I have a gentleman with a beard in jail Zoom 3. Can I ask your name, please?
Joseph Brown.
Mr. Brown. All right. And then I have a gentleman in jail Zoom room 4 with a yellow scrub outfit on. So what's your name, sir?
Antoine Carter.
Okay, so Mr. Carter. All right, I'm going to change your name. All right, so Mr. Brown zoomed in first. So let me grab your file, Mr. Brown. This is in the matter of the people of the state of Michigan versus Joseph Brian Brown, file number 24-22087FH. I have Salvatore Malaro appearing on behalf of Mr. Brown and Douglas Hartung appearing on behalf of the people. This is a date and time set for a pretrial conference. Mr. Malaro, how do you wish to proceed today? I'm sorry, Mr. Malaro, we have no audio on you.
Can you hear me now, Judge?
I can hear you now.
Okay. So Your Honor, I'm going to ask to adjourn this as well. I'm going to need to sit down with Mr. Hartung and see if, and then Mr. Brown and see if this can be resolved short of trial.
All right, so I will adjourn this to April 23rd at 8:30 in the morning. Mr. Malaro, can you do the stipend order to adjourn?
Yes, Your Honor, I will do that.
Your Honor, can we push
And
that to April 30 by chance?
I can, yes. So we'll set it over to April 30th at 8:30 in the morning. And Mr. Malaro will do the stipend order. Mr. Hartung, can you sign your name with permission?
Absolutely.
And then, Mr. Malaro, if there is a resolution and you want him brought in sooner or on a different day, just let us know and we'll schedule it in, all right?
Yes, Your Honor.
All right, thank you, Mr. Brown. You're all set. All right, Ms. Demont, you represent Mr. Cooper.
Yes, Your Honor.
All right, this is in the matter of the people of the state of Michigan versus Anton Carter, file number 24-22086FH. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Mr. Carter. So let me change this because I had Mr. Murphy as his attorney. All right.
Your Honor, I am Mr. Carter's attorney, I thought.
I thought you
Ms.
said Cooper.
Demont- Oh, you're on Cooper. Okay, never mind.
Did you say Cooper or Carter? I'm sorry.
You're Carter, right?
I'm Cooper.
I know, well, actually, you're Dumont, but in the gentleman in jail Zoom, you're Carter, right? Anton
Yeah.
Carter?
Yes, Your
I'm
Honor.
sorry. Yeah,
Sorry.
okay. Sorry. All right, so let me get Mr. Murphy. So, Mr. Murphy, how would you like to proceed on behalf of Mr. Carter?
Your Honor, can I speak to Mr. Carter in a breakout, please?
Yes. So I'm gonna open up a breakout room. And make more breakout rooms. Sorry, Mr. Carter. All right, so I'm gonna put you and Mr. Murphy into a breakout room. Just go ahead and join it. And then when you're done, you can either stay in there and I'll bring you back, or you can come back on your own. All right, there you go. All right, now I have another gentleman wearing glasses in jail Zoom 6. What is your name?
Demario Cooper.
All right, now I have Mr. Cooper. All right. This is in the matter of the people of the state of Michigan versus Demario Cooper, file number 25-22134FH. I have Dave McCready appearing on behalf of the people, and I have Katerina Dumont appearing on behalf of Mr. Cooper. Mr. McCready, thank you. I do have in my file a plea agreement form. I also have a pretrial assessment that was completed by Darren Coast, our pretrial services coordinator. Mr. Cooper scored a 4 on the assessment, which puts him in the moderate range to reoffend or not make future court dates while out on bond. He lives very far from Adrian and has several fraud offenses on his criminal history. Indicated his current case involves restitution potentially of $72,000, which is an alarming amount. And they say that his current bond of $90,000 appears appropriate. So, Mr. Mott, how do you wish to proceed today with Mr. Cooper?
Your Honor, I spoke with Mr. Cooper yesterday. We talked about the plea agreement we got from prosecutor. We would like to accept that, but instead of pleading guilty, we would ask to plead no contest. We did send your office an updated plea, signed plea form.
All right, and Mr. McCready, any objection to a no contest plea?
We're fine with that.
All right, so Mr. Cooper, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record?
Demario
Hold on.
Cooper.
All right, Mr. Cooper, I've received a plea agreement form that was provided to me by your attorney in the prosecutor's office. So the plea agreement, as I understand it, will have you pleading no contest to count 2, uttering and publishing, which carries a maximum penalty of up to 14 years in prison. And to count 5, state identification card, counterfeiting, forging, using to commit a felony punishable by 10 years or more. And that one also could carry up to a $20,000 fine. So do you understand those counts, sir, that the plea offer has been made on?
Yes.
Okay, I'm gonna need you to speak up a little bit. You're kind of soft-spoken, so we have to record this, okay?
Yes, Your Honor.
Okay, so Mr. Cooper, you understand the maximum penalty on those offenses then?
Yes, Your Honor.
And Mr. Mont, the purpose of the plea, lack of memory or civil liability?
Civil liability, Your Honor.
All right, now, Mr. Cooper, there's a, all right, so Mr. McCready and Mr. Mont, there's a sentencing agreement that he would serve 36 months to 14 years with the Michigan Department of Corrections.
That is part of it. That we're asking that be suspended for 1 year, so that he can be under supervision and pay the restitution that he's promising. And if he successfully does the year under supervision, that we would amend the agreement to a probationary sentence with no upfront incarceration.
Are you expecting them to pay $72,000 in the next 12 months?
Correct.
And Mr. Mont, your client thinks he could do that?
Yes, Your Honor. The only issue he had is that he does have some other cases in other states that likely when he's PR'd here, he'll get taken to, but he said once he's released from incarceration in other states, he can work towards paying that.
Okay. All right. And then I would set sentencing out 11 months, Mr. McCready?
That's fine. Yes, please.
Okay. All right. So, defendant, part of the agreement is defendant must pay restitution in full before sentencing. If he does, the people will amend this agreement to a probationary sentence with no upfront incarceration. Additionally, while on supervision, waiting sentencing, and while on probation, if probation is imposed, defendant will either remain on a tether or regularly report in person to probation as recommended by the probation department. It's my understanding. Okay, so Mr. Cooper, the pretrial services coordinator said they thought you lived far away, but you live in Detroit. That's not that far, right?
Yes.
Okay, all right. All right, so do you fully understand the plea offer, Mr. Cooper?
Yes.
And do you wish to plead no contest to those charges and enter into this agreement?
Yes, Your Honor.
Now, $72,000 is a lot of money in restitution, and I don't know what your other cases are. So you believe that you can pay that in the next 11 months?
Yes, Your Honor.
Okay, all right. So, are you satisfied with Mr. Mott as your attorney and the advice that she's given you?
Yes, Your Honor.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. McCready
That is correct.
and Mr. Mont
Correct.
and Mr. Cooper?
Yes, Your Honor.
Okay. Now, if a guilty or if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Cooper, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Cooper?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All
No, Your Honor.
right, so Mr. Cooper, how do you wish to plead to the charge that on or about, the right one, on or about February 8th of 2024 in Tecumseh Township in the county of Lenawee, that you did commit the offense listed under count 2, uttering and publishing? Now your response will either be not guilty or no contest.
No contest, Your Honor.
All right, and on that same date and time and in Township of Tecumseh, how do you plead to the charge listed under count 5, state identification card, counterfeiting, forging, using to commit a felony punishable by 10 years or more? No contest or not guilty?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. McCready?
No, Your Honor.
Ms. Damon?
No, Your Honor.
Has your attorney promised you any particular sentence or estimate what your sentence will be other than the agreement that was placed on the record, Mr. Cooper?
No, Your Honor.
All right, is it your own choice to plead no contest?
Yes, Your Honor.
All right, so who will be placing the factual basis on the record?
I will, Your Honor.
All right, very good.
I've emailed to the court and to defense counsel a 9-page extract from the police report in this case. It's from various locations within the police report, and I'd like to highlight a few items within that, if I may.
So I have not read that, so as long as you just get enough for the factual basis.
Yes, he's being charged as an aider and abettor to the principal offender in this matter, who's Aaron Higginbotham, who's already been convicted. And it's alleged that on February 8th of 20, 2024. They went to 8080 Matthews Highway in Tecumseh. Deputy Brendan Wright was dispatched to Tecumseh Harley-Davidson dealership at that address for a fraud. The complainant was from Tennessee and stated someone had financed 2 motorcycles in his name for $60,000, and they were purchased at this Harley dealer. Deputy Wright had contact with Jaden Harris by phone as he was located in Tennessee. Jaden stated he received proof of insurance in the mail for 2 motorcycles. He immediately looked into this and thought it was suspicious. He canceled the insurance and spoke with Harley-Davidson about filling out a fraud packet. Jaden stated he has never been to Michigan and definitely did not purchase these bikes. Deputy Wright then had contact with Jeff Myers inside the Tecumseh Harley-Davidson store. Jeff is an employee there. He stated that on 2/8/2024, 2 black males entered the store and inquired about buying motorcycles. He advised they decided on a bike and began the process of a credit check loan approval through Harley. And that's the basis of the uttering and publishing, by the way. Jeff stated Harley came back and approved everything quickly with no suspicions under the name Jaden J. Harris out of Tennessee, which is the ID the suspect provided. And that is the basis of the state ID charge, which is count 4. Jeff stated he believes the subjects arrived in a Chevy Tahoe, but one of the suspects drove a bike off the lot that day. He stated they came back the next day after the second bike had a few upgrades done and drove it off the lot. Jeff was able to provide me with a photocopy of the ID the suspect used out of Tennessee with the name Jaden Harris out of Tennessee. Detective Sharp from the Sheriff's Department had contact with Austin Michael Garcia, who's a employee of Harley. He provided an image of the defendant, Mario Alonzo Cooper, and Deputy Brendan Wright went to talk with Michael Garcia and advised that he showed Austin the image, and Austin told him that that was the person with the suspect here in Higginbotham when the 2 bikes were fraudulently purchased. So there we have the identification of this defendant as being with the principal. Austin told me he recognized the male, the Mario Cooper, in the image because he spent 2 days with the male in that image and the other male, Aaron Higginbotham, processing the sale of the 2 Harley-Davidson motorcycles. Austin further advised that the male in the image, Mario Cooper, asked him if his friend Aaron Higginbotham could finance a bike for him because he had bad credit. Austin advised that they were able to finance both bikes under the other person, Aaron Higginbotham. Moving on to page 8. And again, this is just indications to confirm that this defendant knew that Aaron Higginbotham was processing a fraudulent credit application and providing a fraudulent ID because Detective Sharp had contact with lead fraud prevention officer Dory Field of Harley-Davidson Financial Services on June 26, 2024. Dory indicated that during her investigation, she obtained 2 counterfeit Oklahoma driver's licenses with the same images that were presented during a fraudulent purchase of 2 Harley-Davidson motorcycles from Hideout Harley-Davidson in Oklahoma on March 31st, 2024. Dory provided those 2 counterfeit Oklahoma driver's license, and Detective Sharp viewed those driver's license and determined that one of them bore the picture, the image of Demario Alonzo Cooper, this defendant, that he knew through this investigation. So with that, I think we've established a factual basis.
Mr. Mott, anything you need to add?
Oh, Your Honor, we're satisfied.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about February 8th of 2024 in Tecumseh Township in the county of Lenawee, that the defendant did commit the offense listed under count 2, uttering and publishing and correct me if I'm wrong, by filling out a fraudulent credit application to get approval to purchase a Harley Davidson motorcycle through, I think you said Tecumseh Harley Davidson, knowing that that instrument was false, altered, forged, or counterfeit. And it was drawn on the name of a Jaden J. Harris, paid to Harley Davidson through the bank of Eagle Mark Savings Bank. And the amount was $35,449.86 on that count, although there is count 3 with $36,545.59 for the other motorcycle, which is where the total restitution comes from. And the same offer was gave to the co-defendant to pay restitution as well, so he wouldn't necessarily have to pay the full amount if his co-defendant also pays, correct?
Restitution is joint and several. So yes, it'll be a maximum of that amount between the two defendants.
Okay. And then under count 5, based on that information, he used a state personal identification card that had been altered, counterfeited, or forged to help him get approval on the credit application. So therefore, the court accepts the no contest plea to count 2 and to count 5. Anything else on that, Mr. McCready?
No, Your Honor.
All right, has the court complied with the MCR 6.302 B, C, and D, Mr. McCready?
Yes.
And Ms. Dumont?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court personally has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement that was placed on the record through the prosecutor's office and counsel for the defendant. I'm going to refer this matter to the probation department for a pre-sentence investigation. So I'm going to set this for 8, 9, 10, 11, February 20th of 2026. Ms. Demont, what other jurisdictions have a hold on Mr. Cooper?
I believe the next place he'll be going is Ohio, Sandusky County.
Okay.
And then there may be something in Louisiana, I'm not sure. And then maybe a probation violation in Pennsylvania.
All right, so the moment I release him on a PR bond, if there's any holders, he's going to be taken somewhere else. So Mr.
Yes.
Cooper, I don't know where you're going to end up. It sounds like you have a little bit of traveling in front of you to these other states if they have pickup orders. Mr. Stevenson, do you want to talk to him real quickly just to get information? Because I'm going to PR bond him and then who knows where he'll go.
Yeah.
All right, so Mr. Cooper, someone's going to try to meet with you before you get taken away for the pre-sentence report. When you meet with them, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide a copy to Ms. Demont. She'll try to review that with you before sentencing. It's very important that if you get out of jail in Ohio or you get out of jail in Louisiana or wherever you may be, that you Google Lenawee County Circuit Court and get a hold of us somehow so we can get information to you on how to proceed, all right?
Yes, ma'am.
And you'll have to at some point meet with the probation department for them to get that information. If you don't get out of jail before the 11 months is up, send a letter to Ms. Demont, have somebody reach out to us because we will take into account the fact that, you know, you're stuck somewhere else, okay?
Yes, ma'am.
Okay, so I'll set sentencing for February 20th of 2026 at 8:15. I'll put that's going to be in person, but like I said, when you get out of jail, don't forget to get a hold of Ms. Demont, all right?
Yes, Your Honor.
Okay, All right, so Mr. Stevenson, I'm gonna put you in a breakout room with him. He's gonna just get some information, like maybe family members or something, so we can try to keep track of where you are, okay?
Yes, Your Honor.
I cannot. Oh, here we go. Hold on. All right, so no. 2006. All right, Mr. Stevenson and Mr. Cooper, go ahead and join that breakout room. All right, Mr. Carter, I'm going to come back to you. In the matter of the people of the state of Michigan versus Anton Carter, file number 24-22086FH. Mr. Murphy, have you had an opportunity now to speak with your client?
Yes, Your Honor. Thank you for that breakout session. Your Honor, the
Hold on one second, and I'm going to release Mr. Cooper and a Pierre Bond. That wasn't clear. Okay. All right, now go ahead. I have received a plea agreement form on Mr. Carter that states that the defendant will plead guilty to an added count 2, resisting and obstructing a police officer, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. Count 1 will be dismissed, which was an obstruction of justice, and that any sentence he receives will run concurrent with any violation probation sentence pending for December of 24. So, Mr. Carter, are you on circuit court probation?
Yes, Your Honor.
Okay, who's your PO?
Matt Stevenson.
Oh, Mr. Stevenson. All right, he'll be back in just a second. All right. So
Your Honor, just for clarification, there was a pending violation of probation down in district court when we had the probable cause conference for this case. That's the violation of probation that's being referenced, and Mr. Carter was sentenced by Judge Shather to 1 year in jail on that violation of probation in December. So that's just for clarification. That's our understanding of what the plea offer was referencing.
But he's on probation in circuit court too.
I understand, Your Honor. Again, it's a lot of clarification. That was the pending sentence that was we were discussing.
Okay. 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 Mr. Carter, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Can you state your full name for the record for me?
Antoine Deontay Carter.
All right. So, Mr. Carter, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an amended information with an added count 2, resisting and obstructing a police officer, which carries a maximum penalty of up to 2 years in prison?
Yes, Your Honor.
All right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the sentence running concurrent. Is that correct, Mr. Sneed?
Yes, Your Honor.
And Mr. Murphy?
Yes, Your Honor.
Is that correct as far as you're aware, Mr. Carter?
Yes, Your Honor.
All right. So, Mr. Carter, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Carter?
Yes, Your Honor.
Say it a little bit louder for me.
Yes, Your Honor.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Carter?
No, Your Honor.
All right, Mr. Carter, how do you plead to the charge that on or about December 6th of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense under count 2, resisting and obstructing a police officer? Guilty or not guilty?
Guilty, Your Honor.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
So other than any sentence you serve would be concurrent, Mr. Carter, has your attorney promised you any other particular sentence or estimated what any other part of that sentence would be?
No, Your Honor.
All right, Mr. Stevenson, you just popped back in, but Mr. Carter is pleading to an amended information to account 2, resisting and obstructing a police officer, with the agreement that his sentence would run concurrent to his district court violation of probation sentence. He's currently on probation with you, Mr. Stevenson?
He was previously.
Not now, though?
No.
Okay. He thought he was, but
I can check his status. See if there's a warrant for him.
okay. All right. So, Mr. Carter, it's your own choice to plead guilty, right?
I thought I was on probation with Mr. Stevenson here.
Maybe. He's looking right now.
Judge, it'll be a few minutes if you want to keep going with him.
Okay. All right. So, but is it your own choice to plead guilty, Mr. Carter?
Yes, Your Honor.
Okay. So, Mr. Carter, on December 6th of 24, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right. And did you come in contact with someone, was it the Lenawee County Sheriff's Department or the Adrian Police Department?
The Adrian Police Department.
Okay. And did you try to hide from them to avoid being arrested on a warrant?
Yes, I was in the closet.
Okay. All right. Are you satisfied, Mr. Steen?
I am, Your Honor. Thank you.
Okay. Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed
Yes, thank you, Your Honor.
and Mr. Murphy?
Yes, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the plea agreement that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing for May 2nd at 8:15 in the morning. Any information, Mr. Stevenson?
Yeah, Judge, he is not active on probation. He was discharged a while back.
Okay, so that's good news, Mr. Carter. You're not on probation. All right, right. So I'm gonna set this for sentencing on 8/15. Now, you already got sentenced in district court, right?
Yes, yes, Your Honor.
When's your out date on that?
I was never given an out date. I just been kind of looking into my own time. They told me, well, someone tried to run my information. They said my out date would be possibly September 6th this year, but they wasn't sure if that was correct or not.
You got a year downstairs then?
Yes, ma'am.
Okay. All right. So do you want to appear for sentencing via Zoom or in person?
I say via Zoom.
Okay. So, Mr. Carter, someone from the probation department is going to come over and meet with you. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Murphy. He will meet with you in advance to review that. And we will see you back here on May 2nd at 8:15. All right?
Okay. Would this person from probation be from circuit or from district court?
Circuit court.
Okay.
Maybe Mr. Stevenson.
Okay.
All right.
All righty.
Thank you,
All right.
Mr.
Thank you,
Carter.
Thank you, Mr. Carter.
All right. Thank you.
Bye.
I'll talk to you soon, okay?
All right. I'll talk to you soon, man. Appreciate your time.
Yep, take it easy. Thank you.
All right. Is anybody in the courtroom a defendant? Got a court case? No, we're just here to watch. You got a court case? What's your name?
Sarah Fonseca.
All right. And you do too?
I'm here for my grandchild.
Okay, but you're not a party. Okay. So Ms. Fonseca, let me see who your attorney is. Mr. Malaro. All right, why don't you come up to the podium?
Mike Stevenson.
So this,
Tom Moore.
Mike, I'm gonna mute you. Okay. All right, this is in the matter of the people of the state of Michigan versus Sarah M. Fonseca, file number 24-22038FH. This is the date and time set for pretrial in this matter, third pretrial. I have Salvatore Malaro appearing on behalf of Ms. Fonseca, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, how would you like to proceed today?
But if we could have one more adjournment, I think we can get this worked out with Mr. Sneed and I.
All right.
I just gotta wait for Mr. Sneed to be in a good mood.
Okay. All right. He's always in a good mood. All right. So, Ms. Adams, I'm going to need a notice of hearing for Ms. Fonseca on this. I'm going to set this out to April 30th at 8:30 in the morning. Obviously, Mr. Malaro, if a plea agreement is struck that Ms. Fonseca wants to avail herself of, I'd be more than happy to schedule it in on a day that's not a Wednesday.
Absolutely.
So, we'll do the notice of hearing. So your pleas continue, or not guilty pleas continued, as is your bond. So have a seat on that bench behind you, and we'll get you a notice of hearing. All right. Anything else, Mr. Sneed?
Maybe I'd be in a better mood if I took as much vacation time as Sam.
Oh, that's
True.
so unfair and true.
Me too. Me too. All right. So,
Thank you, Judge.
thank you. Is that all you have, Mr. Malaro?
I have a Macy Wilt and a Malika Rembert, I think.
Let me look. I have Malika Rembert. Is there a Malika Rembert in the courtroom? Let me check my Miss Fonseca. Thank you. All right. All right, so Mr. Malaro, I do not have Malika Rembert present, and I do not have Macy Wilt present. I do show that, so in the matter of the people of the state of Michigan, is anybody here from Macy Wilt? No. In the matter of the people of the state of Michigan versus Macy Alexandra Wilt, file number 25-22131FH. I do have a letter from Darren Coast, my pretrial services coordinator, who states that Macy Wilt is missing drug screens and not returning his calls. She is not present today via Zoom or in person. I do show a proof of service was mailed out on February 12th of 2015, or may have been, yeah, it was mailed out to her. So, Mr. Malaro, any further information you want to add?
Yeah, Judge, she had a matter down.
Can't hear you.
How about now? Can you hear me now?
I can hear you now.
Okay, Judge, she had a pending matter down in Toledo that we were trying to coordinate with. Let me look up the docket down there and see if something happened with that.
Okay.
So if we could pass on that for a few minutes.
Sure. So then I have in the matter of people of the state of Michigan versus Malika Nataya Rembert, file number 24-21966FH. I have Salvatore Malaro appearing on behalf of Ms. Rembert and Isaac Sneed appearing on behalf of the people. So I do have a notice of hearing that was mailed for today's date by my staff back on February 5th. I do have a note that Ms. Rembert was being released to Harbor Light. Do you have any information on that, Mr. Malaro?
Yeah, Judge, she's been down in district court numerous times. She's always shown up. I think she did complete the rehab at Harbor. I may have sent that or may not have sent that to the prosecutor's office. But if I could give a moment to see if I can reach her.
Sure.
So if we could pass on that as well.
All right. Mr. Murphy, do I have Mr. Murphy? I don't have Mr. Murphy. Oh, I do have Mr. Murphy. All right. So let me look at my jail list.
John, I don't think any other people I have are in jail because I have Caleb Daniels, Alexia Rowe, and Blake Barton. Are you trying to come in?
Hold on. In the matter of the people of the state of Michigan versus Caleb Robert Daniels, file number 24-22081FH. I'm Matthew Murphy appearing on behalf of Mr. Daniels. Did I let him out of jail? Was he in our recovery court? He's absconded again?
Yes.
Okay, so that's file number 24-22081FH. Matthew Murphy or Isaac Sneed appearing on behalf of the people. Matthew Murphy appearing on behalf of Mr. Daniels. So Mr. Murphy, he's also on bench warrant status for some of his other files. He is not here. And we haven't heard from him, so I'm going to issue a bench warrant for his arrest if I haven't already. Thought I already did, but I'm going to set bond in the amount of $25,000 cash. We hear from him though. We are looking for him.
Yes, Your Honor. The last I'd known, he was going into transitional housing, I thought.
No, he didn't. So, let's see. He did not. Blake Barton.
You know, I think Mr. Barton's trying to connect to Zoom right now.
Okay. Alexia Rowe. In the matter of the people of the state of Michigan versus Alexia Jovan Rowe, two files, 25-22136FH, 25-22137FH. I have Matt Murphy appearing on behalf of Ms. Rowe and Alexander Vianetto appearing on behalf of the people. I have a letter dated March 17th from Darren Coast. Ms. Rowe was switched over to recovery court colors. I am no longer monitoring her. She did test for me on March 4 of 25 and was completely negative. And has she been attending our court?
She has, and I saw her yesterday. She came in and signed an ROI.
Okay, so Ms. Rupley said she has been compliant with recovery court and met with Ms. Rupley yesterday. She's not here today. So I would tend to say that's probably some confusion on her part because she's been doing everything she's supposed to do. So Mr. Murphy, what I'm gonna do is adjourn this.
Thank you, Your Honor.
And do you want a week, 2 weeks? Well, 2 weeks, 3 weeks?
Yeah, probably 2 weeks. I'm gone next week. I do have an offer from the people. I think it's going to be resolved at the next court date. Just a matter of getting here, there, and getting it figured out. So,
How about April 9th?
yes, Your Honor.
All right, so I will set this over to April 9 at 8:30 in the morning. And Mr. Murphy, can you do the step in order to adjourn? Mr. Bandetto, can you sign your name with permission?
Thank you, Your Honor.
Yes, Your Honor. Thank you.
All right, excellent. Thank you. So takes care of her.
Judge, Your Honor,
Yes.
we can take care of Macy Wild if the court's ready on that.
Okay, back on the record in the matter of the people of the state of Michigan versus Macy Alexandra Will. So, Mr. Malaro.
So, Judge, I reviewed the docket down in Lucas County. She is currently on what's called a capias, which means she did not appear for court. And there is a bench warrant issued for her arrest, so I cannot account for her whereabouts at this time.
All right, so I'm gonna issue a bench warrant for her arrest for failure to appear, and I'm gonna set bond in the amount of 50,000 cash. All right, Malika Rembert.
Judge, I left a message for Miss Rembert. She usually responds. I could have a few more minutes.
Okay, all right, are you Blake Barton?
That is Mr. Barton. I can recognize him.
Mr. Barton, can you hear me? Okay, I'm gonna send him a chat to disconnect from his Bluetooth in his car. Sometimes. All right, I just sent a message. Can you disconnect from Bluetooth? You seem unable to hear us.
I can hear you now.
Oh, great. So this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 2023-21272FH. I have Alexander Bayonetto.
Yes.
Appearing on behalf of the people, Matt Murphy appearing on behalf of Mr. Barton. This is the final pretrial in this matter. We are set for jury trial on April 11th a bench trial. I'm sorry, we're set for a bench trial on April 11th of 2025 at 1:30 p.m. Today is the final deadline for all motions as well as amended witness list being due. So, Mr. Murphy, are you prepared to go to trial?
Your Honor, may I have, well, I am, but could I speak to Mr. Barton in a breakout, please? Just to get an
Sure.
update on.
All right, so let me open up a breakout room. go ahead and join that breakout room. The record in the matter of the people of the state of Michigan versus Miguel Mansour. This was a time set for arraignment. Mr. Mansour is self-represented and a guest of the Michigan Department of Corrections. So it looks like a public defender was ordered to sign a waiver on behalf of the client, but he didn't have an attorney, so a waiver was filed, but it's not a valid waiver. Mr. Sneed, can you verify whether or not because of that, whether or not a writ was done from MDOC?
If I get it 1 second, I do see a writ, but I think it's outdated from in March.
All right, Miss Adams.
I did get email confirmation from MDOC. We changed it to Zoom because they couldn't get him here or something.
Okay, and then they just still didn't get him here. All right, so I am going to set this over. Miss Adams, 1 week, 2 weeks, what do you think? 3 weeks?
I don't know if he was requesting to be here in person. I know we have prints, so I would say 2 weeks to be safe.
Right, it says MDOC Zoom, so let's just do Zoom for April 9. At 8:15, and we can do a new writ and whatever else needs to be done to try to get him here. And wants to come in person after that, you can. All right. All right, Mr. Malaro, are you ready to, oh, no, let's see. Mr. Malaro, any information on Rembert?
Judge, she has not yet called me back.
I can't hear you, Mr. Malaro.
Can you hear me now?
I can hear you now.
Your Honor, she hasn't called me back, but she's always showing up for court. Would you be agreeable to allow me to take care of some Judge Olsaver cases and then come back and see if she shows?
Just adjourn it. If she's always appeared, I'm not going to issue a bench warrant. Why don't I set this out to April 9th? Is that all right, Mr. Malaro?
Yes, that would work, Judge.
So we'll set Ms. Rembert out to April 9, and Ms. Adams, can we mail a notice of hearing? So that way it's a court one. All right, so Mr. Malaro, thank you. We'll see you back on that one on April 9th at 8:30.
Thank you, Your Honor. Appreciate it.
You're welcome. And I think that's all I had, Mr. Malaro, with you. So I'm going to put the courtroom in the waiting room. I have a class here, Mr. Sneed, I'm going to talk to you real quick.
Your Honor,
Yes,
do you have Angel Rosas on your docket this morning?
I do. She is Rhonda Underwood's client. And so Rhonda Underwood goes to Judge Olsaver first and then to me,
Okay.
but she's not here.
Angel Rosas, I haven't seen her.
Yeah, I haven't seen her either.
Okay,
So
I'm her foster care worker.
Okay.
We've got court at 1:30 today too, so I'm just trying to.
she got court today.
She will at 1:30 for probate.
So I'm wondering if she got confused. That's good to know though. Thank you. All right, Mr. Murphy, are you ready? I'm Mr. Barton.
Yes, Your Honor. I was gonna just place on the record our understanding of the plea agreement at this point. Now, we've had prior to the last scheduled bench trial, a conference with Your Honor, myself, and Mr. Bayonetto. And I relayed that, my understanding of that to Mr. Barton. Our understanding was that the offer from the people was for Mr. Barton to plead to an OWI second, dismiss the remaining charges, and that Your Honor had agreed that he would be sentenced to fines and costs if that was the case. Now, I just wanted to clarify and make sure that that we are correct on that, and if we're incorrect, we just like for the record to be cleared on that in regards to what the offer is.
OWI second, which is a 1-year misdemeanor, and what was the rest of it?
That Your Honor had agreed that he would be sentenced to fines and costs.
Mr. Bayonetto, is that your recollection?
It is, Your Honor. We did have a bench conference as it related to that, and I indicated to Your Honor that I would leave any issue of probation or sentence to Your Honor's discretion. And at the end of that conference, you did indicate that fines and cost was going to be your presumptive sentence.
In this case, Mr. Murphy, part of that was based on the fact that the offense date for this was September 10 of 2022. And Mr. Bayonetto, my understanding is there have been no further violations or criminal offenses, correct?
Correct, Your Honor.
All right, so yes, so Mr. Barton, that is the plea offer that's on the record. You're charged with OWI third offense, which carries a maximum penalty of up to 5 years in prison and up to 1 year in jail. Do you understand that, Mr. Barton? Go ahead and unmute your device.
You're muted, Mr. Barton.
Sorry about that.
There you go.
Okay.
All right, and then the plea offer is because this case is so old and you haven't committed any new offenses, that you could plead to an OWI second with fines and costs. And there would be license sanctions, but I have no input on that. So do you understand that, Mr. Barton?
I do.
Your Honor, no.
Also, just for the record, though, our policy has always been if there is a conviction at the end of a trial, I do remand to custody.
Right.
Yes, Your Honor. And because of that, that's the concern that Mr. Barton has is that the custody that he may be taken into if the trial is had. Now, Mr. Barton was asking if it'd be possible if Mr. Bayonetto would be willing to keep that offer open until sometime after today's date. He wanted to have further discussions in person with me and some relatives before we made the decision in regards to the matter. So that's what we're asking for today is if Mr. Bayonetta will be willing to keep that offer open. And if not, I'd just ask if I could do another breakout session with my client.
Well, one, you can have a breakout session with your client if you want one, because I already gave you one. And two, I will, Mr. Bayonetto, I can set this for another pretrial on April 2nd, if you're willing to leave that open to April 2nd.
I am, Your Honor. Your Honor, I would ask, maybe could we do next week? Because I do have to.
I'm not here. It's
Oh, you're not
break.
here next week. So April 2nd would be the next date. That's fine, Your Honor. I did also have something I would like to place on the record. As I relate to the court at the last court date, ProMedica was giving me some issues trying to identify some witnesses. I heard back this morning from the staff attorney that I had been working with at ProMedica. He indicated he would have names for me within a day or two. If the court is going to allow us to maybe adjourn this a couple weeks, would you allow our amended witness list to be submitted at that next pretrial date?
All right, so Mr. Murphy, we did have at the bench conference conversation about the difficulty with getting information from ProMedica. Court obviously has discretion to allow amended information, and your position, Mr. Murphy.
Well, I think I made the position clear at the conference. You know, this case has been pending for quite a while, so we object to any allowing the prosecution to amend anything, but of course it's up to the court's discretion, but we just want to place our objection on the record for that.
Well, Mr. Bayonetto has made us quite aware of the difficulty that has been involved, so I will allow that amendment of information by April 2nd. All right, so Mr. Murphy, if you can do the stip in order to adjourn to April 2nd at 8:30. Mr. Bayonetto, you could do an order allowing you to amend the information or the witness list by April 2nd, and we will see you back on April 2nd at 8:30 in the morning.
Thank you.
Thank you, Your Honor.
Thank you,
All
Your Honor.
right, thank you.
Mr. Barton, contact my office, schedule that appointment, okay?
Okay, sounds good.
Thank you.
Thank you.
Okay, so.
I think that's all that I had, Your Honor, if I'm not mistaken. We dealt with Mr. Daniels, right?
Yep, we're all set with Mr. Daniels.
Ms. Rowe, we adjourn. Okay. Thank you, Your Honor. That's all that I had. You have a good day.
All I have left is Rhonda Underwood.
Okay, thank you.
Oh, what's your name?
Rowe.
Say it again.
Rowe, Alexia Rowe.
You're Rhonda Underwood, though. No?
No, Dan Murphy.
Oh, well, he's gone. Oh,
Ms. Rowe was
for,
that's what I was gonna say.
we set a pretrial for.
They gave it to me. I just wanted to stick my head in here to make sure you knew I made it.
I'm like, wait a second, I don't have you. No, yeah, we set it over because I knew you were doing what you're supposed to do. So Teresa spoke up, so you're good. So
I appreciate you.
it's all right. I appreciate you. Have a good day.
You too.
All right, so I got nothing except for Rhonda. So 2 of the public defenders go to Judge Olsaver first, 2 of them come to me, and then Rhonda Underwood handles a lot of the MDOC cases and some of the more serious cases. So she just goes back and forth. So she'll pop in at some point. Any other questions? No? Do you? Okay. Yeah. All right. So many years ago, I was a public defender and it was a contract through the circuit court. And guidelines through the Michigan Indigent Defense Commission required that each county go to a separate public defender's office. And so we have several public defenders now that work under the head of a chief public defender, just kind of like we have a chief prosecutor. and other prosecutors under them. They're funded through the county and federal grants and state grants, and they're available for people who are indigent. So how many of you could pay an attorney $25,000 right now? Nobody, right? So if you are under the poverty level and you need a criminal defense attorney and you're facing jail, you have an absolute right to a public defender. And so those attorneys will represent you on your criminal case. Some people have a mistrust of attorneys in general and will represent themselves, and they do have the right to do that. So I would say probably, I don't know, Spade, 85% of the people that come through the criminal justice system have a public defender. The rest of them do retain private counsel, but that is expensive. Depending on the nature of the case, you could pay anywhere from $15,000 to $50,000 for a criminal defense attorney. There are, low-level felonies, low-level misdemeanors, and high-level felonies. This is circuit court, so we only hear felony cases, so cases where you could go to prison. District court only hears misdemeanor cases, and those are cases where you can only go to jail. So it's cheaper to hire a misdemeanor attorney, of course, than it is to hire a felony attorney. So that's the public defender's office. And I think we have about 1, 2, maybe 7 or 8 of them. And they're across, where the old pretty courthouse is, they're across the street from that on the other side from us. And then we have the prosecutor's office, and they're housed in the building here. And some people do go pro per without an attorney. And like I said, they have the right to do that. It's sometimes difficult because even though I'm an attorney, I'm a judge now, so I can't give legal advice. So I can't help them. And that is difficult because sometimes they do need help. And let's see what else. And we have Michigan Department of Corrections is our probation office. That's through the state of Michigan. And so on Tuesday mornings, it's really busy here because I have people reporting for felony probation and parole. So people who have been released from prison on parole. Let's see what else. Sentencings are on Thursdays and Fridays, and I do YouTube these. I don't YouTube like civil cases or family law cases or cases involve minors. I don't YouTube those just because they are minors, and like you guys, I would never have your case. If I have certain cases with minors, I close the courtroom and everybody has to leave. So I do have quite a few young adults who are charged as adults, even though they're minors, and I have them on probation. And so when they come in and out of court, we're not live on YouTube and the courtroom's closed. So, and then juvenile court is on the 2nd floor, and those are for juveniles that are charged as juveniles, and they can be anywhere from 8 years old to 18 years old. Let's see. So you guys mostly learn criminal law, right? Is that what you're both mostly focusing on? All right. Anything else?
First semester we did criminal law, and then we spent some time in mock trial. Just in the past 3 weeks or so, we switched to civil.
Okay. So we're a small county, so I have a criminal docket, a family law docket, and a civil docket. So I hear custody cases. Some of you may or may not have come in and seen me because I do interviews with children to help determine custody cases. So I do divorce cases, paternity cases, people who aren't married and have children. I do child support enforcement, which is one of my favorite dockets. So we show cause people when they don't pay their child support. Let's see, divorces, custody cases. I have a civil docket. So it can be anywhere from a personal injury case involving medical malpractice, like, you had surgery and they left a sponge in your abdomen, to loss of a child, obviously through childbirth, car accident cases, pedestrians getting run over cases, So I do all of it. When you say you're studying civil law, what kind of cases have you talked about?
So far, we've done a little bit on torts and contracts and warranties.
Okay.
So different types of warranties, we'll be starting family law.
Okay. So out of my dockets, I would say that my criminal docket's my favorite docket. And then just because it's fast paced, so you can see like we're really busy, we got people moving in and out all the time. I enjoy that. I enjoy working with the recovery court team, which has been really successful as a resource for people with recovery issues. And then my civil docket, I rarely see them. They come in for pretrials, and most of those cases will settle before they ever go to trial. So I rarely interact with them. And then family law is probably the bulk of what I do. So the majority of my time is spent doing family law cases. So Wednesday mornings, I do a criminal docket, pretrials and arraignments. Fridays and Thursday mornings, I'll do sentencings. And then I have civil pretrials on Mondays, all day in motions. So Mondays like motions and pretrials on my civil and family law cases. And then the rest of the time is just evidentiary hearings. So I can have up to 7 evidentiary hearings a day. I might go 8 to 9, 9 to 10, 11 to 12. You know, we go pretty much nonstop from 8 to 12 every day and 1:30 to 4:30 every day. We kind of need another judge here, but that's not an easy thing to do. Our dockets are kind of overwhelming at this point, just because the number of cases. And I think a lot of it is due to, you know, it wasn't this bad before the pandemic, and we're definitely caught up from the delaying cases from the pandemic, but our county as a whole seems to be suffering from more mental health issues, which we have a lack, you know, we have resources, but we need more resources. And obviously funding is hard to get to hire all those extra people. So while we don't seem to have more new filings, we have many, many, many more filings within custody and divorce cases where children are being moved back and forth. We have some people here today who work on the neglect abuse cases, and those are cases where, you know, a child, there may be a report from a mandatory reporter, like your teacher is a mandatory reporter. So if one of you come in and you have bruises or disheveled, or they just notice something's wrong, if they think there might be abuse or neglect, they have a mandatory requirement to report that to the Department of Health and Human Services or Child Protective Services. So we've had an uptick in filings and abuse neglect cases. And they can be horrifying, and sometimes they're easily remedied. So CPS and DHS go in, they try to put a plan in place, they try to give resources to help people, and they'll do a lot of that before it ever would go to court. And a majority of the time people put those things in place and they never go to an open court. But we have severe cases where people are sexually abusing their children, violently assaulting their children, starving their children. They're living in neglect. I used to go into homes sometimes because I was a guardian ad litem that represented the best interests of the children, and conditions in some of the homes were just so sad. So we have an uptick on those cases, and those are probably the hardest cases to do, I think. And so I give a lot of respect to the people that do that on a daily basis. So those are the hardest cases. I do have a docket for that, an overflow docket, really. It's not really what I'm assigned to, but I'm assigned to it because there's an overflow, because I'm like the chief judge of like everything. So, so any questions? You guys are so quiet. You know, I go to Clinton High School and we do site visits. We love going to schools. So I go to elementary schools. I go to Clinton High School. I do travel, and I have a judicial attorney who, hey, Becky, can you see if Sierra will pop in? I have this judicial attorney. She's like a big like a little tiny golden retriever, but she's got like big energy and she gets so excited when we go to schools, and then she doesn't let me talk. But she went to U of M for undergrad. She went to U of M for law school. She's brilliant, and I'm like super lucky to get her. And she is my judicial attorney. She does all my research. She drafts my opinions. And then she's also the court administrator, and she's also my ADA coordinator. And there she is. So that's Sierra McGrain. And she, I think, works with your school to help. Do you help them bring it in, or?
I talked to their teacher.
Yeah, there she is. So she's wonderful, and she goes everywhere with me. Yeah, she's like my second daughter. Her and my daughter actually look a lot alike, except my daughter is like freakishly tall, and yeah, and so they tend to go everywhere with me. Yeah, so we go to Renaissance fairs. We go to.
I'm like a dog. I just get in her car.
If I open the door, she hops in. So, yeah, and so they're kind of quiet.
I see.
So one time we had a class, elementary kids are fun. So one time I had a kid, he's like, so he was like second grade. He's like, so when my dad and I went to the gas station and my dad pumped gas and then he drove off real fast. Did he commit a crime? And I'm like, yeah, probably, you know, but so little kids tell me everything. Like, my dad has a safe where he keeps all his marijuana. They'll tell me stuff like that too. Kids are fun. So,
well, at least he keeps it in the safe.
yeah, at least he keeps it in a safe, but.
Thank you for acknowledging that.
Yep, and that's like a huge pet peeve for me, because I think, you know, yeah, marijuana is legal.
Yeah.
But that means your kids should never smell like it.
Yeah.
You know, like I'm Gen X. I would spend hours in a car with my parents and they're smoking a pack of cigarettes with the windows up. So I abhor that. Like when I walk into a school and I smell kids that smell like marijuana in elementary, no, that's like a pet peeve of mine. So anyway, I told them all about you. She went to Michigan. I went to Michigan State for law school, but UT for undergrad. I was a high school teacher for many, many years before I became a lawyer.
You lived many lives.
I lived many lives. So any questions? They're so quiet. Anybody in marching band? All right, I'm gonna put the courtroom in the waiting room for a minute. All right. Rhonda Underwood,
Yes, ma'am.
okay. I think I have. Hey, this is Judge Ann Sloan. I am ready for Miss Quinones.
Okay, we'll get her in.
Awesome, thank you. All right, Rhonda, I have a Jessica DeLeon, but no, I don't. She left. Okay. So Rhonda Underwood, in the matter of the people of the state of Michigan versus Kaylee Dawn Lake, file number 25-22146FH. Rhonda Underwood appearing on behalf of Miss Lake. I thought you were one of the students, but she is. Okay, Miss Lake is not present in the courtroom. Miss Lake is not present via Zoom. I have Alexander Bayonetto appearing on behalf of the people. So Miss Underwood, have you heard from Miss Lake? I do have a notice that we mailed out on February 19th, scheduling it for today.
Hang on, Your Honor. I will. Okay. I tried to reach her. I left her a message, Your Honor. That's the last I've heard of Ms. Lake. I can't understand why she wouldn't be here.
All right, well, I will issue a bench warrant for failure to appear. I will set bond in the amount of 25,000 cash. We hold those for 48 hours.
Thank you.
So Miss Underwood, if you reach her, just let us know. All right.
Okay. Thank you.
All right. So Miss Underwood, moving on to in the matter of the people of the state of Michigan versus Kaya Serena McKay, file number 23-21323FH 22-21047FH. What did you guys say you were hearing again?
Angel Roses.
Okay, so Miss Underwood, this is a date and time set for a probation violation. I believe we were here previously and she failed to appear, so I adjourned it to today. But again, she has failed to appear.
I tried to reach her, Your Honor. One moment. I don't see that I was able to reach her, Your Honor.
All right. So I will issue a bench warrant for failure to appear on both files. And I will set bond on each file for $750 cash for a total of $1,500. All right, Ms. Underwood?
And is that another 48-hour hold, Your Honor?
Yes, we're mandated to wait 48 hours before signing bench warrants for failure to appear.
Thank you.
Okay, so Ms. Underwood, in the matter of the people of the state of Michigan versus Angel Rosas, file number 25-22142FH. We do have a notice in the file that a notice of hearing was mailed to her on February 19th. Ms. Underwood, she is not here, but I've also been made aware that she has a hearing today at 1:30 in the family division of the probate court. So there may be some confusion there. So if you No,
Believe,
she's,
I believe I talked to Miss.
hold on,
Lake.
Miss Underwood, hold on. So I'm getting information from caseworkers that she's not appearing or in compliance there. Is that correct?
Correct.
So,
No, that is just.
no, it doesn't matter.
Hang on. Yeah. Boy, we are.
What's your name?
Kristen Smith?
Kristen Smith with a K?
Yes.
Okay, I tried to reach her. I called and couldn't leave a message.
All right, well, I will issue a bench warrant for failure to appear and I will set bond in the amount of 25,000 cash. All right. And obviously hold that for 48 hours.
Thank you.
You're welcome. Thank you. Good luck. All right, so Miss Underwood, the last one I have is Miss Quinones, and we are waiting for the jail. Is a kid here? Okay. Why don't you place the kid in the jury room by herself? Themselves, and then just tell them we're gonna shut the door and they'll be fine. And then I have to finish my criminal doc.
Yeah, that's exactly what I was telling him.
It only counts when I say it though.
Exactly. Anywhere I go, that's the way.
Listen to all the women in your life.
Lots of women in my life too.
He has 4 daughters.
There's a class in observing today. Where are we from? St. Gregory. All right. You've got a good judgment.
Thank you.
So I get to do some pomp and circumstance. Woo. All right.
You always do pomp and circumstance. He's a lawyer, if you couldn't tell. All right, Miss Underwood, we're just waiting then on Miss Quinones. I have 1 million jail rooms open. So after this at 10:30, I'm scheduled for a custody case. So that's why they're all writing up. What time you have to be at the jail?
Around 10:30.
You ever watch the TikToks on prison food?
Oh, yeah.
You know how they make like all this crazy stuff from commissary foods?
Yeah.
Yeah. It always amazes me in other states, like MDOC prisoners can have a phone. Because you can't have a phone here, but in our prisons, so. Oh, Miss Underwood, I do see your chat. I think it is you. Yeah.
I'm by Zoom, Your Honor. It can't be.
I'm gonna take some files to Miss Adams.
Reached out to them all ahead of time and.
I know.
So she's playing on YouTube, so I don't want to tell the story. But I will give the story.
Please rise for personnel session.
Yeah. All right, nice. Anything else? Any questions? No, teacher? Anything?
They were asking me about.
All right, so Ms. Quinones, can you hear me?
Yes, good morning.
Good morning. So Ms. Underwood, this is in the matter of the people of the state of Michigan versus Nicole Michelle Quinones, file number 21-20669 FH, 21-20668 FH, 22-20832 FH, and 22-20833 FH. I have Brenda Underwood appearing on behalf of Ms. Quinones, and this is the date and time for probation violation. Ms. Underwood, I do have an email from Jennifer Walsh. Did you receive that?
Your Honor, if I can just speak with Ms. Quinones for a second, we should be able to dispatch this very quickly.
Okay, so Ms. Quinones, I am going to put you in a breakout room.
Okay.
With Miss Underwood. Go ahead and join that, all right?
Okay.
Thank you.
To talk. All right, Ms. Underwood, I'll bring your client back. Ms. Underwood, I have students from a local high school here, so when I put the courtroom in the waiting room and you can't hear me, it's because I'm talking to them. All right, so Ms. Underwood, we're back with Ms. Quinones. So how would you like to proceed?
Your Honor, I would just like to briefly say, I too am in the possession of the email from Ms. Walsh. And I believe the proposal that's been made since Ms. Quinones has resolved the case in district court and also, Your Honor, has done a considerable amount of jail time up here. The case, as I understand it, Ms. Quinones will plead guilty to the violation. Ms. Walsh has agreed to a recommendation that PSI will be waived, and Ms. Walsh will recommend time served and termination from probation, Your Honor.
And Mr. Stevenson, do you want me to forward that email to you?
I do have a copy of it, so I'm aware of that.
Okay, all right, so your client's going to plead guilty to the violations. I have a couple, so she's gonna plead guilty to those. Okay.
Yes.
So Ms. Quinones, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record, please?
Nicole Michelle Quinones.
Quinones, all right. So, ma'am, you've heard, is it your intention today to plead guilty to the violation of probations?
Yes, Your Honor.
Now, you understand that you're currently on probation for, assault and battery on file number 21-20669 FH, which carries up to 93 days in jail. You're on probation for Larceny less than $200 on file number 21-20668 FH, which carries 93 days in jail. You're on probation on file number 22-20832 FH for absconding bond, which carries a maximum penalty of up to 2 years in prison. And on file number 22-20833, you are on probation for, let's see here. Did I have you on that one? For absconding, an attempted absconding, which also carries up to 2 years in prison. So you understand those are the maximum penalties if you were to plead guilty and be found guilty, but there's an agreement through the probation department that if you're willing to waive a pre-sentence report, we would sentence you to 93 days in jail with credit for time served on each file and revoke and terminate your probation. So is it your intention then to plead guilty to those violations, probations on those files?
Yes, Your Honor.
All right. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
All right. Do you understand that you do have a right to contest this violation of probation charge and to have a trial on it? Bless you.
Thank you.
Yes.
Do you understand that throughout?
I understand
Yes.
that.
I hate
Yes,
to
I
interrupt.
understand that.
It was my understanding it would be time served, Your Honor.
Yeah, well, she's
I
got
believe-
way more than 93 days in.
Okay, thank you.
Okay. Do you understand that, ma'am, throughout the trial, if you chose to have one, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
All right, so Ms. Quinones, on each of these files, how do you plead to the charge that you violated your probation by being arrested for disorderly conduct on December 27th of 2024?
Guilty.
All right, and you actually pled guilty to a disorderly, is that correct?
That's correct.
All right, and then, okay. And then did you fail to, how do you plead to the charge that you failed to notify your probation officer within 24 hours of police contact? Guilty or not guilty?
Guilty.
All right, and that you were engaged in assaultive, abusive, threatening, or intimidating behavior against someone with the initials of TM, guilty or not guilty?
Guilty.
All right. Has anything, do you understand that by pleading guilty, you'll be giving up your right to a trial as I've already explained to you?
Yes.
Okay, other than the plea
Understand.
agreement, has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
All right, if I accept the plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes, it is, Your Honor.
All right, so ma'am, you were arrested and charged with disorderly conduct for an assault against an individual with the name of TM, is that correct?
Yes.
And you actually pled guilty and were sentenced to a jail term for that?
Yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Now, Ms. Quinones, you do have a right to have a pre-sentence report done. Are you willing to waive that and be sentenced today?
Yes, I'm willing to waive that.
All right, Ms. Underwood, is there anything you'd like to say on behalf of your client?
Just that we're happy after all this time that this resolution has taken place, Your Honor. And I think that Ms. Quinones now can concentrate on her circumstances and really starting fresh, Your Honor.
All right, Ms. Quinones, is there anything you'd like to say on your own behalf?
Just thank you, everybody, and like I can't wait to start fresh. I really can't get to my family.
How long have you been in jail?
72 days with 2 days time served in December, I believe.
Okay, all right, so anything else, Ms. Underwood?
Nothing else, Your Honor.
All right, it's sent to the court. You'll be given credit for 72 days in Lenawee County Jail, and we will revoke and terminate your probation. So Ms. Quinones, they're going to give you a ton of copies of notice of right to appellate review. You're gonna have to initial and date one for each copy, for each file. You do have the right to appeal the sentence, and if you wish to appeal the sentence, you would fill out the copies that you keep and mail them to the address listed on the form within 42 days, all right?
Okay. So when do I go
All right, good
home,
luck.
guys?
I hope so. All right, you
All
have
right.
a good day.
Thank you, you too. Thank you.
Bye.
Good luck,
Have a great
Nicole.
one. Thank you.
All right, and Ms. Underwood, I believe that concludes your docket.
It does. Thank you, Your Honor.
All right, thank you.
You already signed up for it. Just missed the order, not.
What?
You want me to get the?
Judge, are we all set?
We are all set.
All right, thank you.
The type is back there.
I understand. There's no name.
Shall I just go to?
I could go with any. This is a detective.
That's the only reason I brought it to you.
Reject. This is a different date. All right, so I am going to stop YouTube.